Right, I think we'll start now. I mean, some people might join us later, but I think it's probably a good time to start. So good afternoon and welcome to the latest in the Five Stone Buildings webinar program, which I think is pretty well established by now. Hopefully, some of you know that I'm Jordan Holland, and I'm going to be talking with Rose Featherstone-Hoare today about Trust and Divorce and 1975 Act spouse claims. I've got a pretty formal thing that we apparently have to do before we start, so it's just a couple of basic housekeeping rules. At the bottom of your screen, you'll see that there's a question and answer box. If you've got any questions throughout the webinar, then please do use this to ask them, and hopefully there'll be some time at the end to answer these, but actually we do have quite a lot of content, so I don't know how many we will have an opportunity to answer, but hopefully we'll have time for some. I'm supposed to advise you that this webinar is being recorded, so if you don't want to be identified when you're asking your questions, then please tick the anonymous box when entering the text for your question, so that I don't identify you in my response. A copy of the recording is also going to be available on our website. I think we now have a YouTube channel shortly after this. And to get the best view of the webinar, we recommend that you view it in speaker view so that it switches between me and Rosie as we're speaking. If you've got any questions after the webinar's taken place, please don't hesitate to contact us by email. You can find details on the website in the usual way. And there's also lots of details there about the previous seminars and also the upcoming webinars. Right, okay, well, I think I'm going to start. So, as I said, thank you for joining. I think Rosie and I's purpose in putting this talk together was really to address some of the issues that arise most frequently in spouse claims. And they fall into two categories for the purpose of today. There's the first are divorce claims involving trust, so they're obviously in the lifetime of both spouses. And then the second is under the Inheritance Act 1975 Act, which are claims after death, obviously. So what we're proposing to do is to give an overview of the two areas and how they intersect with each other, and then just flag some, I think, of the most frequent issues and things for you to consider, in particular things that Rosie and I have seen in these types of claim. There's quite a lot of content to get through, and lots of these issues do warrant their own talks, which I think we'll be saying quite frequently, and some of those talks may follow if you're lucky. But hopefully it will give us, it will just give some signposts really, and things to think about when these types of claims arise in your own practice. So after we're done dealing with the principles and those issues, we've prepared a worked example, which I think, just to warn you, it's a little bit nerdy, classical, but we've tried to make it fun.
Really though.
Yeah, it's not great. But anyway, so we're already on the first slide. So I'm going to start then with divorce claims involving trust. Now, I think if you read the reported judgments from divorce claims which involve trusts, then it's quite easy to forget the basic principles which the family division is applying in these types of claim. That jurisdiction, it's not an inherent jurisdiction, and it's not kind of been established for all time, notwithstanding that quite a lot of the principles which the court apply are pretty much, so kind of telescoping that kind of Mostyn approach, are obviously judge-made. It's actually a statutory jurisdiction, and the statute in question is the Matrimonial Causes Act 1973. And for the purposes of our talk, there are two key sections. The first is section 25(2)A, which says that the court shall in particular have regard to other financial resources which each of the parties has or is likely to have in the foreseeable future. And it's under that category that you will be looking at trusts as one of the financial resources of one of the spouses. And in the reported cases, it's often the case that it's the husband, but in fact, in one of the most important cases, of course, it was the wife. But the second provision is section 24(1)(c) of the 73 Act, which deals with the court's power, which says that in relation to a nuptial settlement, an order varying for the benefit, that the court can make an order varying for the benefit of the parties to the marriage and of the children of the family, any antenuptial or postnuptial settlement made on the parties to the marriage. So could we have the next slide, please, Joe? Yeah, so then that brings you on then to the first question, and that's really whether or not a trust or a settlement is in fact a resource of the husband or wife within the meaning of section 25(2)(a). Now, it's important to start by saying that the question really is not whether or not the husband or the wife, as I'll go on to explain in a little bit more detail, is the settlor of the trust, or whether or not they're the trustee of the trust, although sometimes they're both, and sometimes they're neither. And if a spouse has a fixed interest, then of course that's, so a life interest, for example, an income interest, then of course that income is going to be taken into account as a resource of the spouse. Where the difficulties, or where all of the battle lines are drawn in these type of cases, is when one of the spouses has a is an object of discretion under either a partially discretionary trust or a fully discretionary trust. And the courts have dealt with that in this way. So the key case here is the Charman case in 2006, which said essentially that the relevant question is if the spouse asks the trustees to advance the whole, or indeed part of the trust capital to them, would they be likely to agree to that request? Now, of course, if the answer is yes, they would advance the whole, then that is likely to mean that it's a resource of the spouse in question. If it's only part of the trust capital, then it will be that part which becomes a resource of the spouse. But so that question then, it's clearly not enough that you're an object in itself. What I suppose what you're frequently looking at is whether or not the person in question, either in relation to the whole or part of the trust capital, is regarded as the principal beneficiary. And I think the Charman case emphasises that paragraph 12, that unless the trustee is not discharging their duties properly, i.e. got some kind of sham arrangement or something like that, then it's not really necessary to ask questions about control. And that was put rather well by Mr. Justice Lewison, as he then was, in I always pronounce it Wally, some people say it's Whaley.
Wally?
Yeah, I know, it's weird, isn't it? But I think it's Wally, but I wasn't in it, so I can't pronounce their name. But yeah, so in the Wally case at 113, Lewis and Jay already summed up that the question is about access, really. It's about access to the resources rather than the control of the resources. So, for example, you may have a spouse that is a trustee of a family trust, to which they don't necessarily have access, even if they are technically a beneficiary. And that wouldn't be a resource of that spouse, because that would be about control of the assets rather than access to the assets. And so basically, to cut a long story short, if the relevant question is answered in the affirmative, i.e. they've got the trustees will be likely to agree, then that's a nuptial settlement within the meaning of the Act and a resource of the spouse for the purposes of the divorce. Can we have the next slide, please, Joe? Right, and this is my last slide for a while, so you'll you won't have to listen to me any longer. So
listening to you.
If then it is a nuptial settlement, it is a resource of the spouse, what can the court do? Well, as is underscored in that thing, the first point to note is that if it's not nuptial, then the court has no power to vary. So no matter how big the trust is, if the court just can't bring itself, and the court often does bring itself and tries very hard to bring itself to a position where it can say that it's a nuptial settlement. If, however, the answer is in the negative, then the court has no power. So it won't be a resource of the spouse, and it will kind of fall out of account for the purposes of calculating any ancillary relief award or financial relief award, as we should probably call it now. So if, however, that it is nuptial, then there's two ways that the court can approach the matter. The first is that an award can be made to the spouse from non-trust assets, which leaves the other spouse, the beneficiary spouse, to call on the trustees for those assets. So that's what happened in Charman. And so 87% of non-trust assets worth 48 million was awarded to the wife. So of course, that's an unusual award, in the sense that it would be unusual for one spouse to get 87% of the joint pot, as it were. But what the court does there is say, you know, we know that you have access to these trust resources, and so we take that into account. And essentially what the wife got there, taking into account the trust assets, was less than 50%. I think it was considerably less than 50%. So that's one way that the court approaches it. And that's, I suppose, the most bullying way. Bullying is probably the wrong word, but that's the kind of the most robust way of approaching it, because it leaves the spouse with this obligation to basically hand over all of the non-trust assets. The places that you have problems with that approach is if the vast majority of the wealth is held in the trust, because of course you do often see cases where they essentially live from trust income, at non-fixed trust income, and all of their, you know, even in quite wealthy families, all of their property, both realty and personalty, is held by various different trusts. And so that approach can be quite difficult in those cases, because there just isn't enough non-trust assets out of which to make the award. The second method is the judicious encouragement method. So what happens then is that the court makes an award which it knows that the spouse will not be able to satisfy unless monies are actually advanced from the nuptial settlement. And it encourages, judiciously, hence the judicial encouragement, it encourages the trustees to use their power their powers to advance funds to the husband, if it's the husband or the wife, to the spouse, in order to fulfill the award. Now, it has to be said that they are usually made in pretty strong terms, i.e. the court expects to do this, etc., etc. But as Miss Justice Lewison said in Whalley, the court won't put undue pressure on the trustees. So it's, you know, it's not a question of the court saying do this or else. And the last bullet point is the limits of judicial encouragement orders, and that is the limit, is that they're unenforceable against the trustees. So it's not an order that the court says you must exercise these powers, which the spouse, who is the beneficiary of the award, can enforce against. It's essentially saying, oh, the court expects you to do that. Now, if the trustees are thinking about their powers in a proper way, it is often the case that they will comply with the award, but that is not invariably the case, and that's really the limits of the jurisdiction. And there's, in particular, if they're onshore professional trustees, then it's very likely that they will comply with the award. If they're offshore professional trustees, then it can often be quite difficult to make them comply, because they simply say, well, that court, this trust is not an English law trust. We haven't submitted to the jurisdiction, because invariably offshore trustees will not submit to the jurisdiction in divorce claims. And therefore, you can't make us, essentially. There's a slight caveat to that, is that it's often, if the trust is a Channel Islands trust, it's often easier, and they will comply. So essentially what often, not always, but what often happens in Jersey and Guernsey is that the trustees will make an application to the Royal Court to bless the exercise of their discretion in order to fulfil the award. And the Royal Court has, there's various different judgments saying that, in the general course of things, the Royal Court will bless that and will expect the trustees to do that. So the Channel Islands jurisdictions are slightly easier, but if it's a Caribbean jurisdiction or Bermuda, or etc., that can be a lot more difficult. So in those circumstances, those kind of orders can be of limited benefit. And finally, another limit to judicial encouragement order is that if the trustees are non-professional trustees, then they're obviously much less likely to comply. If they're just family trustees, or family and friends or whatever, then they may well take advice which is to the effect that these are the principles which you just should apply, etc., but this can't be enforced against you. And then they say, well, if it can't be enforced against us, then why would we do it? So that's another problem. But as you can see, if the majority of the assets are trust assets, the matrimonial assets, if they are, the majority are trust assets, then really you're kind of stuck with a judicial encouragement order, because 100% of the non-trust assets may not take you very far. And on that note, I will hand over to Rosie.
Thank you very much, Joe. Could we possibly, Joe and Jordan, thank you. Okay, so now we're moving on to nuptial settlements, which are distinct from whether or not the trust can be considered as a resource of the husband or wife. Because as Jordan explained just now, even if the trust is a resource, if it's not also a nuptial settlement, then you can't vary it. The court has no power to vary it. So you're left with either awarding the non-beneficiary spouse all of the non-trust assets, or a judicious encouragement order, which may sometimes be met with the sort of problems that Jordan's just outlined. But as I will go on to describe, if you can establish that a settlement is a nuptial settlement, this gives the court quite broad and wide-ranging powers to vary it. So, just dealing first of all with what a nuptial settlement is, and it is a bit difficult to define because it is so broad. So just looking at the term settlement to begin with, I think as private client lawyers, we're used to thinking of settlements as express trusts, your usual express trust with trustees and beneficiaries. But actually, settlement has an incredibly broad meaning in this context. For example, in a case which I have no idea how to pronounce, but I think it's something like Busworthic or something. The provision of an annuity by the wife to the husband, so in essence her saying, I will pay my husband X per year, that was considered to be a settlement for the purpose of the matrimonial legislation. So it's incredibly broad. Now looking at the nuptiality requirements, this is also broad, you'll be pleased to hear. In essence, you're looking for a disposition which makes some form of continuing provision for one or both of the parties to the marriage with reference to their married state. Now, quite a useful authority is an authority that on the slide is called C&C, but actually it's more easily memorable if you look at it as Charalambus and Charalambus as the parties are called in the judgment. Now, the question for the Court of Appeal in that case was whether a settlement had retained its nuptial character following removal of both spouses as beneficiaries of the settlement. And the view of the Court of Appeal was that the settlement did retain its nuptial character, notwithstanding that the two spouses had been removed. And that was for various reasons. They'd remained joint protectors of the trust. Their children remained in the beneficial class. And there was also power to add them back in as beneficiaries. And their protector powers meant that they could essentially veto the trustees' powers to distribute or accumulate. This latter point is quite interesting because the Court of Appeal went on to cite authority to the effect that the power to control the disposal of the trust property, as distinct from the entitlement to benefit from it, could give a settlement its nuptial character, even if it wasn't directly benefiting one or both of the spouses. And in fact, Lady Justice Arden gave a short judgment at the end, and her view was that the powers given to the wife as joint protector were themselves sufficient to invest the settlement with its post-nuptial character, because they gave Mrs. Charalambus power over the distribution of income to the children of the marriage. And this in itself was a sufficient form of continuing provision for her. this brings me on to the next point on the slide, and that is the question, which is whether a settlement which is not nuptial at its creation can become nuptialized by the flow of benefits to one or both of the parties to the marriage. The simple answer, I'm afraid, is that the question has not really been finally resolved, at least at an appellate level. The two cases that I've cited on the screen there are both at High Court level. One of them, the first one, is Quan and Bray, which is the Chinese tiger case, which I'm sure we all know and love, in which Mr. Justice Coleridge at first instance took the view that it was possible to nuptialize a trust if in actual fact there was a flow of benefits from the trust to the parties during the marriage. Unfortunately, Quan did go to the Court of Appeal, but they expressly declined to decide this point, which is a bit of a pain, because subsequently in Joy and Joy Maranko, another unpronounceable case, Sir Peter Singer took the opposite view from Mr. Justice Coleridge. The driving point behind his decision on this front appears to have been that if you could nuptialize a settlement, then this would render what he referred to as every truly dynastic settlement, which provided benefits for an individual. If they were then married and the trustees continued to provide benefits to them, that in itself could nuptialize the settlement. And that appeared to be unattractive to him, at least. So I suppose watch this space in case this goes on appeal in a different matter. Joe, could we have the next slide, please? Thank you. So, nuptial settlements part 2. And what this slide looks at is what property is actually subject to the settlement and what the settlement actually is. Because often there will be scenarios in matrimonial finance proceedings where the overlying trust or the trust itself cannot be said to be a nuptial settlement. And this is absolutely not fatal to a section 24(1)(c) order, because there's a very strong line of authority in the family division in which the court has held that property held within a trust, or often even by a company that is itself held by a trust, is subject to a nuptial settlement. And this is useful in to spouses who are trying to challenge trust, because it gets around the sort of Preston Petrodel type problems that you might get if you were trying to obtain a property transfer order under section 24(1)(a) of the MCA, where you're trying to get the company itself to transfer property. So N and N, the first case on the screen, is a good example of this, because the matrimonial home was held within a Bahamian company, which was held by a trust. I think I've said Guernsey Trust, but I think it was actually a Jersey Trust, of which the husband was a beneficiary. Now, it was common ground between the parties that the overlying trust was not a nuptial settlement, but Mr. Justice Coleridge held that the property, the matrimonial home within the trust and held by the company, was subject to an anti-nuptial settlement, which could therefore be varied. Now, the second case on the screen, Ben Hashem and Ali Shaif, upheld this decision. Similarly, this regarded a property in which the wife was residing, which was held by a company. Mr. Justice Mumby decided that the property that was held by the company was subject to a settlement, although it did not extend to the entire leasehold interest of the property. He decided that the only property that was settled and that was the subject of the settlement was a revocable license to occupy. So you can see that you can have a huge range of different decisions, from deciding that the entire matrimonial home is subject to the settlement, or, as in this case, just the right to occupy, which was terminable. There's also another interesting case called the Brown Sugar Trust case, in which Mr. Justice Mostyn considered that the company holding the property could also be considered to be itself a nuptial settlement, so long as it made some form of continuing provision for one or both of the parties to the marriage. So again, you have this incredible flexibility in this jurisdiction, where quite a lot of arrangements that might not seem to a trust lawyer like they would be settlements are in fact considered to be so for the purposes of section 24(1)(c). So how does the court exercise its jurisdiction to vary nuptial settlements? Well, in theory, the court's power is is unfettered and unlimited, and can go so far as to direct the transfer of trust assets to the wife or husband, absolutely. But it can be as limited to, well, as in Ben Hashem, it can be as limited to varying the settlement to give the wife not less than 6 months' notice to quit, which is what Mr. Justice Munby did in that case. And this latter point demonstrates how important it is to identify the property which is subject to the settlement, because if the property subject to the settlement is just a license to occupy, the court can't then direct the transfer of the underlying property itself. And in fact, Mr. Justice Munby was asked to do this by counsel for the wife and expressly declined to do so. But looking at it in more general terms, the starting point, section 25, which Jordan's outlined, which lists numerous other factors, including the financial resources of the parties. And the overriding aim is really just to do justice in the individual case. The courts won't interfere with the settlement more than is necessary for the purposes of achieving a just result. And in particular, the court's going to aim not to interfere unduly with the rights of third parties, particularly where children are concerned. Joe, please could we have the next slide? Thank you. I'm going to whip through this very quickly, you'll be pleased to hear, and then we'll be back on to Jordan speaking about 75 Act spouse claims, which will be fun. So very briefly, the routes we've canvassed so far, that is treating trusts as resources or treating them as nuptial settlements capable of variation by the court. Of course, these aren't the only weapons in the armoury on divorce. And on this slide, we've listed just a few of the other lines of attack that come up again and again in the matrimonial finance cases. So first, we've got the statutory provisions which permit the avoidance or setting aside of dispositions made with the intent to defeat claims for matrimonial relief. Now, in the matrimonial jurisdiction, that's section 37 of the Matrimonial Causes Act. But that can be usefully coupled with an application under section 423 of the Insolvency Act, which has a wider remit. And quite a useful consideration of this is found in the authorities cited on the screen, the first one, B&IB. This is an interesting one because the application was originally under section 37 and section 423, but the husband actually died partway through the proceedings. So the wife intended to replace the section 37 application with an application under section 10 of the 1975 Act, which does not, like section 37, confer upon the court the power to set aside transactions, but does permit it to direct a donee to repay funds to the estate effectively. So Mrs. Justice Parker's judgment covers various issues, but the point that I wanted to pick out for these purposes is her decision that although it's the Insolvency Act, section 423 is not limited to cases of insolvency, but instead catches transactions at an undervalue made for the purposes of putting assets beyond the reach of creditors. So it's actually got an incredibly wide remit. And what's quite useful for the purposes of the matrimonial finance jurisdiction is that section 423 orders may be more susceptible to enforcement in foreign courts by comparison with section 37 orders, because they're not limited to matrimonial claims, and so may well be more attractive to spouses, and unfortunately it is usually wives looking aside to set aside this sort of transaction. Now the other points listed on the screen all do deserve talks themselves, and you'll be pleased to hear that I'm not going to go into them, particularly not going to go into Pugachev, but what they do have in common is that they all involve trust principles that are familiar to us all from the Chancery Division. And what judges both in the Family Division and at appellate level, for example, Lord Sumption in Prest, have really been keen to emphasize is that the family division is not a Wild West. The same legal principles do apply there as in the other divisions of the High Court. So in other words, please do feel free to instruct us for all your chancery/family needs, and we'll be pleased to assist. Please, can I have the next slide, Joe?
Yeah, that's my slide, right?
That is your slide.
That's fine. Yeah, just before we move on from live spouse claims to dead spouse claims, someone has asked a question which I think is probably easier to answer now, which is asking about giving an example of a judicial encouragement order being blessed in the Channel Islands. So most of those applications are in private, or certainly all the ones I've dealt with are in private, because both of the family division proceedings are in private, and it would be an internal application, administration of trust, which in the Channel Islands are still dealt with the court sitting in private. But what you want to look at is, and they feed into each other, the Guernsey and Jersey ones. What you want to look at is the line of authority that starts with Re H, which is a 2006 authority. And what happened is that you have the Jersey court got quite annoyed with the family division, because instead of doing what I was talking about and treating things as a resource of the marriage, and thereby narrowing down the scope of their powers in the way that we discussed to a judicial encouragement order, what the court was doing, the family division was doing, was holding that they were nuptial settlements, so applying the principles which Rosie discussed, and then varying the trust. Notwithstanding that the trustees had not submitted to the jurisdiction, so you got this kind of back and forth between the royal court in Jersey mainly, but the Guernsey court would chip in every now and again, and in a series of cases over about 4 or 5 years, and the English court kind of refusing to back down, as it were. And then I think eventually in the Mubarak case, the English court, I wouldn't say they backed down, but the English court did adopt the approach which in these judgments you kind of get the extraordinary thing of the Jersey courts asking the English courts to adopt an approach which was limited more towards a judicial encouragement order on the basis that they were financial resources of the parties, rather than trying to vary the trusts as nuptial settlements. And then from then on, it all calms down, and you get basically the principle that the court will look on these judicial encouragement orders favourably, as long as that is in accordance with the trustees' duties as trustee. So that's the answer to that question. So, and that leaves us very well onto the end of live claims and the beginning of claims after death under the Inheritance Act 1975 Act. As Rosie has, as Rosie said, the key section is section 1.2a, which provides that the standard which you're applying when a spouse makes a claim under the Inheritance Act is different than all other categories of claims. So for all other categories of claims, it's reasonable financial provision for the applicant's maintenance. Now, under section 1.2a, in a spouse claim by a surviving husband or wife, or indeed civil partner, it's not restricted to maintenance. So it's such provision as is reasonable, not whether or not that's for maintenance. So they're a whole different category of claim, and you can see that in the reported decisions when you get much more substantial judgments in the case of a spouse than you would in other categories of case. The first point to note is that the court will, and these, I think in some ways this is often missed, because the section 3.2 factors, which I'll come to in a moment, and which Rosie is going to discuss one in particular, often dominate these spousal claims. But it is important to remember that the court still has to take into account section 3.1 factors, which it will take into account in all 1975 Act claims, which financial needs and resources of both the applicant who will be the spouse, any beneficiary under the will, and any other applicant under the 75 Act, who of course would be limited to the maintenance standard here. Obligations and responsibilities, whether or not those are legal obligations and responsibilities or otherwise, the size and nature of the net estate, the physical and mental disability of any beneficiary or applicant, and then any other factor, including conduct. But it is the section 3.2 factors, which are unique to spousal claims and which we're going to focus on, in particular the first one, which is the what's known as the divorce comparator. So it provides that when the spouse is making, when a surviving spouse is, or civil partner is making the claim, rather than any other category of applicant, that in addition to the factors that I've just outlined in section 3.1, the court will have regard to what an applicant would have been expected to receive had the marriage terminated in divorce rather than death. And that has kind of taken on life of its own, as it were, and for obvious reasons, that tends to dominate the court's thinking when it's calculating a spousal award. In addition, they take into account the age of the applicant and the duration of the marriage, which I suppose will be taken into account in a divorce anyway, and the contribution made to the welfare of the family. And that's because it's often the case that you have, if you've got a very traditional marriage, that you have one spouse who goes out and has earned an enormous amount of money, while the other one has stayed at home, raised children, looked after the home, and that kind of thing. And the court very firmly must take that into account. So could we have the next slide, Joe? And I will hand over to Rosie to talk about the divorce comparator.
Brilliant, thank you, Joe. Okay, so what are the relevant principles on the divorce comparator? Following what's frequently known as kind of the white and white divorce revolution, in which the House of Lords decided in 2001, really not that long ago, that there should be no discrimination between husband and wife on the basis of who was looking after the children at home and who was going out and earning the crust. What we're looking at here is fairness. There's no discrimination on the basis of somebody staying at home and looking after the children, even if their spouse has been earning £2 million a year in the city, for example. So this is what Mr. Justice Briggs was really emphasising and summarising in Lillyman, which is one of the few reported decisions that we have on the application of the divorce comparator in 1975 Act claims. And he essentially summarised the divorce principles and suggested that this requirement of fairness, this underlying concept of fairness, gives rise to the requirements that are applied every day in divorce proceedings, and those are the requirements of needs, compensation, and sharing. Now, just looking at those three briefly, needs really does what it says on the tin, but it's important to emphasise that it's a flexible concept, and you often hear in the matrimonial cases the phrase needs generously interpreted. This will often be a particularly acrimonious battleground in 1975 Act spouse claims, because even though spouses are not restricted to the maintenance standard in 1975 Act claims, as Jordan pointed out, and they are entitled to look to the lifestyle they enjoyed with the deceased when assessing the level of their needs. You often have need schedules being picked over in huge amounts of detail, usually by children from a first marriage, saying, you know, X couldn't possibly have spent this much money on their lifestyle with the deceased, and costs are often run up that way. But just looking at needs from a purely legal perspective of the divorce claim, needs do trump sharing if an award on the sharing basis is less than on the needs basis. So that's an important thing to look out for, because you sort of want to know as a spouse claimant which it's going to be more beneficial for you to run or focus on, your needs claim or your sharing claim. Moving on to compensation. this comes up relatively rarely, and really what it does is address economic disparity between the parties, such as where one party to the marriage has given up a lucrative career to look after the children, and then on divorce finds themselves not able to go back to work at the level that they may have been at had they not given up their job to look after the children. Now, lastly, looking at the sharing principle, in theory, this applies to all the parties' property, but in practice, the court's usually looking at a division of the matrimonial assets, or what's loosely described as the fruits of the partnership. For example, earnings or investments built up during the marriage. And what can loosely be described as non-matrimonial assets is pre-marriage assets or inherited assets. Those are usually the typical examples given. The biggest exception to that is the matrimonial home, which generally will always be a matrimonial asset, even if it was acquired by one of the parties prior to the marriage. Now, the matrimonial, non-matrimonial distinction usually brings up quite complex valuation issues in the matrimonial finance authorities, particularly where, for example, companies are concerned which one spouse owned prior to the marriage, but the value of which has grown exponentially in the course of the marriage. So then you have immensely complex judgments in the family division, looking at how much of the value of the company can be attributed to passive growth, which was just inherent in the value of the company at the date of the marriage, and how much was due to active effort, sort of matrimonial effort in the course of the partnership. Thank you, Joe. Please, could we have the next slide? Thank you very much. So, having mapped out very, very speedily the relevant principles, we come on then to look at how the divorce comparator might actually be applied in practice and the possible limits of the divorce comparator. And one of the things that it's important to emphasize is that when conducting the divorce cross-check, the court's not going to act as though it's actually conducting ancillary relief proceedings. And this was made clear in P&G, which is another one of the few reported decisions on the divorce cross-check. And the judgment was given by Mrs. Justice Black, as she then was, who is, of course, an experienced family judge. Counsel for the defendants in that case had removed CGT from the value of the assets for the purposes of preparing a divorce schedule, even though in real life terms, because there wasn't a divorce, the CGT would never have been payable. So Mrs. Justice Black concluded, in essence, that it was really unnecessary to go further with the divorce fiction than concluding that the assets would have been divided equally on divorce, i.e. this was an equal sharing case. And the court really should not indulge in an incredibly expensive exercise where you're trying to figure out exactly what tax would or would not have been paid on a divorce, when that's just not relevant to the facts as they are in the hearing, which is that the deceased has died, and often it's not going to be necessary, for example, to sell properties or realise companies and incur CGT and that sort of thing. There are also other limits to the divorce comparator, and I'm just going to give one of the examples on the screen, and that is that there's only one spouse for whom provision needs to be made, and often that can be quite beneficial to a spouse claimant, because they can argue that greater provision should be made for them than would be made on a divorce. Because, for example, there might be no need to sell the matrimonial home to make provision for the needs of the housing needs of both parties to the marriage. Could we have the next slide, please, Joe? This is Jordan coming back to speak to you about nuptial settlements in the context of spouse claims.
Yeah, how exciting, after death. I think we need to move on to the problem, so I'll take it very quickly. So basically, the court has a corresponding power under Section 2(1)(f) of the 75 Act to vary an antenuptial post-nuptial settlement, which the court is basically going to apply the same principles as to as to when it will do that and whether something falls within and is a nuptial settlement, as it would on a divorce. And the case for that is Roberts and Fresco, which is a 2017 case which we've cited there. So I think it might be worth, if we can have the next slide, Joe, moving on to the practical points for litigation. Yes, so basically these are there are the three things that we kind of picked up, which often kind of lead people into error. The detailed schedule, as Rosie said, in these type of cases, the schedule is incredibly relevant, because what the court is looking at is the standard of living between the parties and that kind of thing, and it's picking over these schedules that often takes up the most time in these cases. So it is important from day one, really, to get together a schedule which is sufficiently detailed and realistic to move the claim on. The other thing is that the choice of division. Traditionally, you would often bring a spouse claim in the family division and an unmarried partner claim in the chancery division. The reason you wouldn't bring or you often don't bring the unmarried partner claim in the chancery division is because, other than it's the family division's 1975 Act jurisdiction, it doesn't deal with those types of claims particularly frequently, and so it would be looking. It's often thought preferable to bring that in the chancery. I mean, that's not a slavish principle that you have to follow. And in particular, sometimes if you've got spouse claims in the spouse claims which you might otherwise bring in the family division, if there are other elements to them, sort of chancery elements, as it were, like, for example, if there's a proprietary double claim, like a validity challenge to the will, or a constructive trust claim tied up, then you may choose to bring that in the chancery division, notwithstanding that the applicant is a spouse. And the last point is make sure you join the trustees if you're looking to vary the settlements, because if you don't join the trustees, then the trustees aren't the trustees aren't varying them. Exactly. Right.
Jordan, there's just one. There's another question which I think I just would like to deal with very quickly
Sure.
before we move on to the question, because it's made me realise that embarrassingly there is a typo in one of the slides, and that is the question is whether when talking about Section 37 of the MCA 1973, there's any kind of time limit which has been established. So if you're setting up a trust 5 years ago, is 5 years sufficient time for it not to fall within Section 37? And the typo is that the 6-year time limit is supposed to refer to Section 10 of the 1975 Act and not Section 37 of the MCA 1973, because there's no time limit per se under Section 37, but there is a rebuttable presumption that a disposition has been made with the intention of defeating the applicant's claim for financial relief if made within 3 years of the application being brought. So there's not a limitation period per se, but it's going to be easier for you as a spouse to, well, essentially because the presumption is in your favour if it's made within 3 years of the application for financial relief. Right, should we do the problem?
Yeah, let's do it. We don't have very much time, but
We'll whip through it.
So do you want me to start?
Me start or you start?
Oh, well, I'll start. Okay, so there we are. As we said, it's very classical. So Penelope and Odysseus have been married for 30 years. There's one child of the marriage. Penelope is the homemaker and Odysseus is the breadwinner. 20 years ago, Odysseus left on a work trip to Troy. Penelope heard nothing from him, but remained at home faithful to him, doing her weaving as the suitors piled up at her door. She didn't, therefore, seek a Benjamin order and the presumption of death, but she might have done. Can we have the next slide, please, Jo?
Thank you. Okay, so Odysseus finally returns, but he's barely recognisable. Sadly and unexpectedly, and indeed contrary to the Odyssey itself, he gets into a fight with one of the suitors and dies, which Penelope is pretty devastated about. Next slide, please, Jo.
So Penelope finds Odysseus' will and is shocked to discover that she's been left a terminable life interest in a residuary estate with no power to advance capital, and one of the will trustees is Odysseus' old nurse. I can't pronounce her name.
Eureka.
Who never liked her. Anyway, so what is more, Penelope discovers that the palace is held in a trust, of which she's not a beneficiary.
Next slide, please. Thank you. Penelope is even more shocked to receive a 1975 Act pre-action letter from the witch Circe, who claims that Odysseus lived with her on her island for at least a year and she bore him 3 sons.
Yes, and I have to say the fact that she's referred to as a witch is, of course, a very old school interpretation. If anyone has read Circe by Madeline Miller, we all know that Circe is not, in fact, a witch. But anyway, both Circe and Penelope issued proceedings under the 1975 Act in the Family Division of the Ithacan High Court, where they appear before Mrs. Justice Athena at trial. What happens next? Well, the first thing to note is that Athena hates Circe, which you'll also know if you've read the Madeline Miller thing, so she might want a recusal application. But to move on to the substance of the problem, go. Rosie, I'll hand you. What do we think about Penelope?
Well, I think Penelope has got a pretty cast iron claim for reasonable provision from the estate. As so often happens with, sadly, wives in this context, is that Penelope's been left with no autonomy at all under the will, and indeed no financial security because the life interest is terminable and there's no power to advance capital. So I would say that, obviously, subject to establishing her needs claim and what the assets of the estate are, she does have a pretty strong claim. Would you agree?
Oh, absolutely. I mean, poor Penelope.
Poor Penelope.
She sat there weaving for years on end.
Yeah.
Yes, no, absolutely. I think Circe's in a more difficult position. Notwithstanding, you know, that she managed to bear 3 children in the space of
1 year.
Who apparently were not triplets. So. But yes, notwithstanding that she managed to do that, I think that she is in a difficult position for several things. Is that one, if she's only with him for a year, then has she got standing as a cohabitee? The second point is, if she is not in the category that Penelope would be in, she's in the maintenance only category. So she needs to establish really that it's reasonable that she needs a provision for her maintenance. So the first issue, if she doesn't have standing to bring a claim as a cohabitee because of the 2-year period, then really all she's left with is if she was being maintained by Odysseus. But of course he lived on her island, so it looks more like she was maintaining him rather than the other way around. So it may be that Circe's claim is just a non-starter. Her children will be in a different position because they are obviously entitled to claim as children of the marriage, whether or not not children of the marriage, children of the deceased, whether or not they were being maintained or not prior to the death. But their cases again will still be limited to the maintenance standard, and claims by minor children and of second marriages of second relationships, particularly if it's a second family when there's a subsisting marriage, are a whole other talk, which we may give another day. But yes, and in relation to the point is that, you know, is it reasonable for her to have anything for her maintenance, even if she is an eligible applicant? Well, unless she can show that Odysseus was that she was financially dependent on Odysseus. So Odysseus had promised her something, then it's probably a bit of a non-starter, to be honest, given the length of the relationship and the fact that he wasn't. And you've got Penelope as a claimant, of course, who's likely to scoop the pool, and potentially the 4 children, depending on what they've been left.
What do you think about the trust of the palace?
The trust of the palace. Well, sounds pretty natural to me. Was the matrimonial home.
Yeah.
So yeah, so for Penelope's claim, yeah, it's difficult. Well, maybe not difficult, but you know, even if that trust started off as non-nuptial, which you'd think that it would, because presumably, unless he built the palace, which I don't think he did, the palace has been handed down through generations of Ithacan monarchs. You would think that the fact that it was a matrimonial home kind of nuptialized that part of the settlement. So yeah, I mean, surely she's going to get the palace. But then,
you'd hope so.
well, yeah, but then you know, it's difficult, isn't it? Because where will the kings of Ithaca live if she gets the palace?
And well, we don't really know whether Telemachus is opposing her claim or not.
No, that's true. He probably will do, though, won't he?
He probably will, you know.
And depending on whether you take it from the Odyssey or not, I mean, he's the one that kind of, you know, caused one of Circe's children to kill Odysseus. So, yeah, could be quite bad for him. But yes, there's all sorts of forfeiture things there as well, which we obviously won't go into today. I think, if I'm not wrong, that is exactly an hour. So yeah, well, thank you for joining us, and our contact details on the slide if you have any burning questions. But yeah, I hope everyone has enjoyed the overview, and we will sign off now.
Yeah, thank you very much.